CR1 is now in session.
Thank you. Be seated. Now is the time set for oral argument.
Pardon me.
And a buzzer, or whatever. Now's the time set for oral argument in cause number 1 CV170555. And I want to say LUJAN, is that right?
Your Honor, Lujan.
LUJAN, thank you. LUJAN versus C&D ENGDAHL et al. For everybody's information, the proceedings are being both video and audio recorded. So barring any technical problems, it should be up on YouTube in a couple of weeks. Counsel, each side will be entitled to the normal 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking all of it from you. But ultimately, that's your responsibility to preserve that. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to the argument. We tell you that so that you can figure out how you want to utilize your time and how you're best served. Counsel, when each of you come to the podium, I would ask that you state your name and who you represent for the record. And with that, the appellant may begin.
My name is Andrew Rotz. I'm the attorney for C&D ENGDAHL LP. We are the appellants in this case. This case is a dispute between neighbors. One party has alleged that they acquired ownership to a disputed strip of land along the boundary between the neighboring lots. But if that were it, we wouldn't be here before the court. We're here because these neighbors live in a planned community where the property owners and the property themselves are burdened by CC&Rs. The appellant's position is that this court should interpret the unambiguous terms and restrictions of the CC&Rs as they were intended, and these terms preclude the relief that Lujan sought and received at the trial court. Appellant's a limited partnership named C&D ENGDAHL, but the partners are Dwayne and Christina ENGDAHL. Mr. ENGDAHL is here today with me, so I'll just refer to them as ENGDAHL collectively and their property as the ENGDAHL lot or Lot 63. The appellee is Kimberly Lujan, who's here in the court, and I'll refer to her as Lujan and her property as Lujan Lot or Lot 62.
Are you saying that in a planned community, the doctrine of adverse possession is simply abolished?
No, that's not what I'm saying at all. I'm saying that the trial court's ruling that the CC&Rs in this case only prohibit voluntary conveyances is an incorrect interpretation and conclusion.
Okay, but how does that address then my concern that CC&Rs are being elevated over the law?
Well, CC&Rs are a contract, as the court knows, and through a contract you can agree to waive certain remedies.
So you are saying that adverse possession is essentially inapplicable because people live in a planned community?
I think that you're interpreting our argument more broad than I'm setting it forth. Our argument is that these CC&Rs specifically preclude the relief that Lujan sought, not that adverse possession as a rule.
There might be some loosey-goosey CC&Rs that don't do that, but we have to be concerned when we hear these cases and write these decisions about the effect they're going to have on others as well. And so if I hear you, what you're saying that people have the ability through CC&Rs to basically contract out of adverse possession.
I am saying that, yes, Your Honor. I'm saying that, and I think that there is case law that would support that position.
What case law?
Okay, so specifically, the CC&Rs are to be interpreted with their ordinary meaning, all right?
Right. Is there any case that says exactly what you just said?
No, there is not a case that specifically states adverse possession can be waived through a contract.
How about nationally? Have you found a case?
No, I have not found a specific case that has our facts and reaches that conclusion, but I haven't found a case that reaches the opposite conclusion, and I have found case law that supports the premise that we're putting forth. And to answer your question, I think that we would look to specifically CSA 13101 Loop versus Loop 101, which is a Supreme Court decision, and it talked about the waiver of statutory remedies. And it found that that you can contract away statutory remedies unless the statute itself is specific in stating that you cannot waive that statutory remedy, if the statute implies that you cannot waive that remedy, or if public policy weighs heavily against enforcing the contract.
So if I do a word search through the CC&Rs at issue here, will I find the phrase adverse possession?
You will not. Okay.
So there was no express waiver.
There's no, well, there's not an express waiver, but I think that in a case like this, if you wanted to draw a distinction, you would have to expressly use that distinction to make an exception for adverse possession, because what the CC&Rs do say is that there will be no further subdivision and that no lot owner can or will convey any portion less than the entire lot. Now, that is a broad prohibition. If the court or if the legislature I apologize, if the CC&Rs wanted to draw a distinction from their broad prohibition, I think that the distinction would be an exception for adverse possession rather than the other way around. But to get back to waiver of...
So what is it about this situation that makes it that the law suddenly is turned on its head?
Well, I don't believe that the law is being turned on its head. I think that you can contract away certain statutory remedies. Now, the plain language says that...
Easily said. Tell
Right.
me in this case
Sure.
how it is that we got where we are under your theory.
Sure. So you have the plain language here, I think, would prohibit any further subdivision or conveyance of a part less than whole. So what the court would have to do would be to say that we're not going to enforce those terms in this situation. And the court would then need to have a justification for that. And I believe that if you read the adverse possession statute, you're not going to see a lot there that would allow you to avoid the CC&Rs.
Do you think
So
adverse possession is a conveyance?
adverse possession, it's not a conveyance until the court rules on it. That's the conveyance. So what you have when you have adverse possession is a property right that you have acquired over a period of time. And that right may vest after you have reached the statutory time period required to meet the elements of the claim. But that does not create a conveyance until you go to court and ask for the remedy. And then when the court grants you that remedy, that's the conveyance, because legal title is transferred at that time.
But who's affecting the conveyance? The court?
Well, the court is effectuating it, but the person who has asked for the remedy is really the one who is creating the conveyance.
They're acquiring. The person who has asked for the remedy is acquiring the land. The person against whom the remedy is issued is not affecting any conveyance. They don't want to convey anything. Their land is being effectively taken from them under the law by the court, right?
But it's a conveyance, and I would cite to Pima County versus Sabino.
Well, but let's look at the language of the contract. The language of the contract says no lot shall be further subsidized, and no portion less than any of all such lot or any easement shall be conveyed by any owner.
Right.
It doesn't say by operation of law, by a court of law. It says by any owner. It seems to me that what it's trying to do is prohibit private deals among different lot owners within the subdivision.
Well,
and that doesn't to me read like a waiver of the law.
Well, there's two parts to that clause, and it seems like that you've only focused on the second part, but if you read it, it says and. The very first part says, no lot shall be further subdivided.
Right.
And no lot owner shall convey any part less than whole. So we have really two prohibitions.
So let's
there.
take the first part. There's no subdivision here, right? We're not creating two parcels out of one. We're changing the boundary.
But you are taking, I mean, to use the analogy that opposing counsel used in their brief, if you have a pie and you split it in two and each person gets one, and then the other person says, actually, I get another piece of your pie, you are subdividing again. It's a re-subdivision. Subdivision is taking something and dividing it into a smaller part.
That analogy, I'm afraid, it is enjoyable, but not entirely availing, because in that analogy, the person who got the second piece of pie now has two pieces of pie.
Right.
In this case, the person whose boundaries are expanded just has a bigger original parcel.
But they have conveyed a second part. I mean, there's an actual conveyance here. The court, in their ruling, has a description of the part that is being conveyed from ENGDAHL to LUJAN. So, I mean, I think it's oversimplifying things to just say, well, now she just has a bigger piece of the pie. You have further subdivided these lots. Further subdivision is very plain and unambiguous.
Actually, we've been talking about adverse possession this whole time, but I think your comment just created a segue to the other theory at issue in the case, right? Which is the change of boundary by acquiescence.
Right.
Would you like to address that?
Well, sure. I think that even a change of boundary, we're redrawing the lot lines. The contract says, the CC&Rs, they say, here's our plat map. Here are where the lines are. The plat map even contemplates that the walls are in one spot and the property line is in another. So to redraw the plat lines, which is what the court would be doing if it were to uphold the trial court's ruling, is a redrawing, it's a re-subdivision. When the declarant owned all these lots and created the planned community, they subdivided that land and created a plat map. To redraw it now is a re-subdivision. Now, since all these people are bound by this contract, what they could do is they could vote. You could vote to change the CC&Rs. You could apply. You know, the issue here, which I'm sure Mr. Connolly will address, is that, you know, there was an attempt to move the wall or the fence to go along the boundary line on the plat map. Well, the HOA has the authority to grant or to deny applications to do that. Why should we get involved in this planned communities setup here? They've all contracted their rights. They have said, hey, we will be bound by these restrictions, but they have a remedy. And that remedy is to amend the CC&Rs or to apply.
Where is the homeowners association in this? Why aren't they in this case? Why didn't they want to be heard? What?
Well, I can't speak to that. They were involved at the trial court level, but merely in a defensive posture. They never really.
But if they care so much about, you know, this implied waiver of adverse possession, you'd think they'd want to be heard. Well,
frankly, I think it's irrelevant whether they care about it, because we're all bound by the CC&Rs here. The HOA, the lot owners, and the lot owners are bound to each other. So the fact that Mr. ENGDAHL is concerned about it is enough, because he has the rights under the CC&Rs to bring an action like this and to enforce the plain meaning of the CC&Rs. So,
does it matter that it's not an express waiver of adverse possession, but that you're asking us to consider sentence fragments and definitions and sort of cobble it all together to waive adverse possession? Does that impact the strength of your waiver argument?
Well,
it would be better, right, if it said you can't, you know, adverse possession, it has no teeth in this community.
Well, it says that we can't redraw these lines. It says that you're not going to re-subdivide and that you can't convey away a part of a whole. So that covers adverse possession. I think that what you're asking is not, you know, hey, you're interpreting sentence fragments. I'm interpreting the whole sentence to say that they would be required to specifically talk about every circumstance under which a re-subdivision or a conveyance would happen is asking for the CC&Rs to be more specific for our purposes today. But the way they're written, the ordinary plain meaning, would prevent this type of remedy that LUJAN sought.
Do you work a lot in this area?
Yes.
This term that we're recognizing as a waiver of adverse possession, is that a common term in CCNRs?
About re-subdivision?
Whatever your argument is.
Yeah, well,
you're looking at a
re-subdivision,
particular
not
sentence.
conveying. Yeah, I mean, when you have a planned community,
This-
you don't want people redrawing these plat lines. So, I mean,
So the effect, what you're asking for today is to abolish adverse possession in planned communities that have this common provision. Isn't that?
no, that's not what I'm asking. I'm asking
Well,
that.
but
that-
what does it mean? Right?
Well,
It's common
what it means,
provision.
yeah. Allow me to address it. What I'm saying is that we should enforce the plain meaning of these CCNRs, because if we don't, if we go the other way and we redraw this plat map, you're creating 148 new adverse possession claims. So what would be the better public outcome? The predictability of the CCNRs, the ability to get a remedy. If you don't like that term, you don't have to buy and be bound by that. If you want to change that term, you can move to have it changed. But to redraw this plat map by the court creates new legal claims all around without the remedy that you would have if it were up to the HOA and to the bargain for rules.
I don't see anywhere where you've challenged boundary by acquiescence.
Well, I believe I don't distinguish the result of the remedy. So,
But they're different claims with different elements, and the differences seem material to your argument. Because on the one hand, you're saying there's a conveyance and a subdivision, and we're creating this extra parcel. On another, in the other claim, you're just moving the line, and the parcels remain the same. So,
but I think that the remedy, the effect is the same, which is why there was no distinction drawn. Because if you are redrawing the plat maps, you're re-subdividing. Whether you're moving a boundary by acquiescence or you're conveying a strip through quiet title, which is what the relief they asked for was quiet title. They filed an action for quiet title. They won on quiet title. And that quiet title was based on adverse possession.
so when we talk about plain language, the plain language of the agreement reads to me a lot like a voluntary act by lot owners. Right?
But it doesn't say a voluntary act. Now the trial
It's
court
adverse possession either. I mean, if we're gonna read plain language, let's read plain language.
Well, here's the difference. You're interpreting voluntary into a clause that doesn't include that word, and you're saying that, on the other hand, we should imply that, or we should suggest that if they wanted to bar adverse possession, they would have had to say that specifically. Yet, on the other hand, if they were only talking about voluntary conveyances, we can just imply that.
No, I'm actually reading that in the plain language.
You're reading voluntary.
I'm sorry if this strikes you as inconsistent, but as I read the language, when it says by any owner, that doesn't just imply, that states an action by the owner.
Okay. Even if that were the case, and obviously we're going to I disagree because I'm advocating a specific position, but I think that even if that were the case, and even if you read that into the second half of that clause, the first half would control. No further subdivision. And I don't think there is any convincing argument that this is not a re-subdivision.
Counsel, you had said something interesting that I don't think is accurate, and I just want to get it on the record. The court quieted title on two independent freestanding theories, on adverse possession and disjunctive boundary by acquiescence.
Well,
Do you, in your opening brief, raise that as an issue and challenge? Right, there are different elements. The elements of that independent basis.
now, let me correct something. What I said was that they didn't bring a cause of action for boundary by acquiescence. They brought an action for adverse possession and a claim for quiet title. Now, you're correct. The court, in its ruling, stated both causes of action. My point was that they had only asked for the one. And then, secondly, my point is about whether I specifically addressed the elements on boundary by acquiescence. The reason I didn't draw a distinction there is because the remedy is the same, and the remedy is what's barred. and the remedy has been waived. So regardless of the two different causes of action, which I acknowledge have different elements, the remedy that Lujan sought and received, she had already waived. She wasn't allowed to seek and receive that because she was bound by the contract. Now, I only have a minute and a half left. There was a cross appeal that I'd like to address very quickly, that I think it's well-established law that you only get attorney's fees on a quiet title action under 121103, that they did not comply with 121103, and therefore the cross appeal should be denied. And I realize I only have a minute 20, but I'd like to reserve some for rebuttal.
Thank you, counsel.
Thank you.
May it please the court. Good morning. My name is Francis Robert Connolly. I am counsel for Kimberly A. Lujan, who is the plaintiff in the action now on appeal, also the appellee and the cross appellant. She, as Mr. Rotz has indicated, is sitting in the gallery. There are two spheres of dispute that we have with regard to this matter. Mr. Rotz has addressed one of the disputes, the ruling with regard to the issue of adverse possession and boundary by acquiescence, and the second with regard to the issue of attorney's fees, and more specifically ARS section 121103B, and whether that can apply in this matter. Given the volume of focus on the adverse possession and boundary by acquiescence issue, I'd like to just cover that very, very briefly and then turn to the the second issue.
So is there any construction within the contract, within the documents, appropriate documents, that would say that adverse possession cannot occur in this subdivision?
There's nothing in the CC&Rs or any of the other associated documents that suggests that adverse possession is precluded or somehow contractually barred.
So it's not raised and eliminated somehow by contract, given that it's a statute.
That's correct.
Question a lot of that, but there's nothing that says that someone couldn't go out there and plant their flag and say, I'm here. This is mine.
That's correct. Yes.
Okay. So it is subject to that. Thank you.
Yes, and interestingly, opposing counsel did cite a case out of Hawaii, I believe it was, that did actually have express language in the CC&Rs that says that indicated that adverse possession was barred as a result of the CC&Rs themselves. But
What if this did say adverse possession is waived? Would that be valid?
Can they contradict statute by contract?
right. I don't think. I believe that would be. That would be my understanding. The contract law and its application to the law in general. Excuse me. I believe that would potentially be upheld as appropriate.
Because in the CC&Rs you can even waive your constitutional rights, right? You can say, I'm not going to post big signs on my property.
Right, First Amendment rights.
Right.
Exactly.
So if you can waive the Constitution, presumably you could waive adverse possession.
That's correct. And nothing in the CC&Rs indicates that. Very, very briefly, the subdivision issue, I don't think it has a terrific amount of merit to it insofar as we're not dividing this property, as Your Honor indicated.
Well, what's the net effect? Is there another parcel created?
I don't believe that there is. No, I think it's just the dispute that we're discussing, Your Honor, is where the proper boundary between these two parcels are.
So
there's two.
As things stand under the trial court's judgment, there's no new tax parcel.
That's correct.
There's no separately conveyable parcel.
That's correct.
Okay.
And I guess
Do we consider, counsel, the significance of this case? How many lots are there?
149.
So we have 149 adverse possession claims that we are stamping effectively today. if we accept your theory?
In theory, I suppose that would be correct. In practicality, there hasn't been a tremendous amount of legal effort in this matter. The only other case that's addressed this issue in the Cortland Village 2 community was presented to the court in 2005 by Eileen Bailey, who is also in the courtroom today, and actually Judge Swan was the judge for that matter. The end results between that matter in 2006, I believe it was decided, and this matter that was decided in 2016.
Right.
were the
I'm not
same.
asking whether or not it's happening. I'm whether or not asking, is that something we should consider?
I believe that you're absolutely entitled to consider it, but I would also urge the court to take consideration of the fact that that if we don't do that, the flip side of that coin would be potentially 149 homeowners knocking down their fences and moving them 5 feet over, and all of these parcels of land experiencing great commotion and construction and impinging in people's backyards that they've enjoyed for perhaps decades, like Ms. Lujan has.
So they could use the 5 feet that's on the other side of their lot that they haven't been able to enjoy for all this time.
That's correct, and would also have to give up 5 feet of their lot that they have been enjoying to their neighbor. So, with regard to the conveyance issue that was touched on,
You know why, counsel? I think I'm reticent to use adjectives, but this seems like a quirk. You have this, gratuitous 5 feet. You know what the reason or the rationale behind that was?
I don't know, and I can't speak for opposing counsel, but I don't think that we ever got a satisfactory answer in the underlying matter during discovery with the Homeowners Association or any other party with regard to what happened. It just looks like it was a Scrivener's error, for lack of a better term, or something
That
like that.
cries out for resolution.
Right.
Thank you.
One case that we cited in our briefing with regard to the issue of conveyance is that to point out to the panel that court action is not necessary to perfect title, but it is not a marketable title of record until there has been a judicial determination of such title. So the issues that the appellant was raising with regard to whether the court's action was a conveyance, I don't think has much merit or carries the day for the appellant. I wanted to turn to the issue of the attorney's fees that were requested in the underlying matter. In our argument, if we were desirous to sum it up in a tidy one-sentence form, would be that a homeowner does not get a 20-day head start in engaging in self-help with regard to property that's in dispute or may actually be the property of a neighbor by virtue of the application of ARS Section 12-1103. What I mean by that is, and as the record indicates, we tried to communicate with Mr. ENGDAHL, the most knowledgeable representative of C&D ENGDAHL LP, prior to the filing of this litigation. As the record also shows, Mr. ENGDAHL was adamant that he was going to proceed forward with this project within a 20-day period, irrespective of our concerns and irrespective of our cease and desist letter that we sent on June the 20th of 2016.
What's your authority, counsel? Well, let's settle first as to what this statute says. Under the precise words of the statute, your client didn't comply.
That is correct.
Okay. So you're asking for some sort of equitable red line or expansion. So what authority do you have that would allow this court to rewrite a statute to reach an equitable solution?
We cited to some case law, Your Honor, in our briefing with respect to the argument that the law does not require a futile act, and we cited to some other cases, Kmart Brothers Enterprises versus Tanque Verde Plaza Company, and Coronado Company versus Jacom's Department Store or Jacom's Department Store. These cases stand for the proposition that even if there wasn't technical compliance with a statute with regard to a tender or something of that nature, there was still deemed to be compliance with the statute because we all knew that the other person was not going to comply with the tender. In the Kammert brothers case, that held that actual formal tender of the amount due on a contract in order to recover damages is unnecessary, where it is clear that the other person would not accept in any event, rendering the actions useless. And in this case, we've got repeated instances of Mr. Engdahl as the representative of C&D Engdahl LP rejecting our repeated communications.
Right, it's not useless. You're saying we got our answer before the 20 days expired.
That's correct.
But where in the statute does it say that's enough to get fees?
Your Honor, it doesn't say that in the statute, but in analyzing the statute as part of the larger and broader case law with regard to the futility of what was ultimately going to happen, it seems inappropriate and offends the policy nature of the statute to essentially allow a person engaging in self-help with regard to property that in this case was deemed to be not his, to have a 20-day lead in order to start tearing down walls and engaging contractors to mark up walls and to red stake Ms. Lujan's front yard and to move forward on a case. It just is inappropriate to require Ms. Lujan to sit on her hands and watch economic waste occur by the knocking down of the wall, which who knows when it would be repaired, since this litigation has been years ongoing. With regard to economic waste and other issues, it just seems inappropriate to require her to wait 20 days, knowing full well that Mr. Engdahl has rejected our requests numerous times and in fact told us to stop communicating with him because he was deeming our communications to be harassment. To force her to wait 20 days in order to be able to assert a claim and recover fees for it. This is particularly true insofar as the policy underscoring 12-1103 is to mitigate the costs and the burdens of litigation in cases where there is a meritorious claim to be advanced.
Have you found a case that says that we can disregard the 20 days if you get an answer sooner?
We have not found a case that established that. No, but the law interpreting ARS Section 12-1103 is not tremendously well, fleshed out. But we have not found a case that indicates that the 20-day period can be set aside for. But again, in interpreting the statute and the policy underscoring the statute with other case law, and as I said, the policy itself, to rule with regard to ARS Section 12-1103 in the way that the appellant urges would essentially allow people engaging in self-help to do what they want for 20 days, and then after the 20-day period, the property owner, the homeowner, gets to go to court and has protection with regard to the fees he or she may be advancing. But then we have a tremendously larger problem on our hand in terms of the self-helping actor engaging in destructive work like was undertaken in this case.
But is that an argument that's best made to this court or down the street to the legislature?
Well, I believe both would be good avenues to raise the issue, but we are raising it here in furtherance of furthering the policy underscoring the statute itself, that to maintain the status quo and to mitigate the costs of presenting meritorious claims. And even if you have a meritorious claim, the statute reads that you have to wait 20 days in order to present that claim if you have if you want to recover attorney's fees, the burden of presenting that claim in the first instance. And so this case is an examination of what happens when a self-help actor is engaging in destructive acts or threatening to engage in destructive acts during that 20-day period. The other issue that I wanted to raise to the court is the issue of the fact that Ms. Lujan in the matter now on appeal was also a counter-defendant with regard to a quiet title action in the underlying matter, and she prevailed in that matter. So not only did she prevail in her quiet title action as against C&D ENGDAHL LP, but she prevailed in defending against the...
Does the statute provide a defensive fee shift?
I believe it does, particularly with regard to case law which has interpreted the statute. And specifically, I would turn the court's attention to Scottsdale Memorial Health Systems Incorporated versus Clark, which holds, quote, the trial court may consider the same factors that are considered in determining whether to award fees pursuant to ARS Section 12-341.01. Obviously, ARS Section 12-341.01 contemplates the prevailing party and the non-prevailing party. So in this instance, the case before Your Honors, Ms. Lujan is the prevailing party not only with regard to her case in chief with regard to quiet title, but she's also the prevailing party in defending against a counterclaim. And again,
is it your position that that counterclaim arises out of contract?
we are of that position, yes. Insofar as all of the issues that were asserted by the ENGDAHLs were predicated upon the CC&R provisions.
Understood.
And I just want to return to the policy determinations which underscore these fee-shifting statutes, and particularly I would cite to Mariposa Development Company versus Stoddard. The purpose of these statutes, or the statute 12-1103, excuse me, is to avoid needless litigation and to lessen the burden imposed upon parties when they're asserting a proper and just claim. In this matter, in the underlying matter, we prevailed with regard to the case in chief. We prevailed with regard to defending against the ENGDAHLs. We were forced to run to court on the last court day before the threatened construction was about to begin. It was going to begin on July the 4th of 2016. We filed on July the 1st. The court in the underlying matter found that we would have irreparable harm if Mr. ENGDAHL were allowed to go forward with his construction work. I think these points satisfy the policy that underscores both ARS Section 12-1103 and ARS Section 12-34101, which the court is allowed to look at in terms of prevailing party analysis. And absent any additional questions from the court, I will reserve the balance of my time.
Thank you. Counsel?
Let me ask you quickly. In your view, could the parties have settled this case, or are they prohibited from doing so by the CC&Rs?
I believe they're prohibited by the CC&Rs.
They couldn't have settled.
Well, think about the demand that Lujan made. Here's a quitclaim deed. Convey me a part of your lot.
Well, how about if your client had just come to the other side and said, you know, there's this issue here. How about we exchange some money and make it all right?
Well,
that couldn't have happened, right?
I'm not sure if the parties could have come to a settlement. I don't think so.
I'm not trying to settle the case.
The answer is no. I think the CC&Rs would have barred it.
Exactly. So
Yes.
so this is an insoluble case in your view.
Correct.
Okay.
So I'm very low on time. As far as the cross appeal, Lang v. Lotzer is on point, and they had a defensive quiet title party in that case. And the Lujan lost on the breach of contract claim, so 34101 wouldn't apply anyway. Two, a question that you had for Lujan was, can a statute be contradicted by a contract? The answer is yes. Swanson and the CSA case say so. Lujan waived her right to this remedy. But I've talked about Section 5.1G, but also under Section 5.1P, this creates a zoning violation. She's not allowed to create a zoning violation. A breach of the CCNRs or an attempted breach is barred, and it can be enforced by Mr. Engdahl. Conveyance by an owner. Who made the conveyance here? We would state that LUJAN caused the conveyance to happen. She asked the court to create this conveyance. She's barred. No owner shall cause any part of a lot to be conveyed less than the whole. Well, LUJAN came to court and said, hey, I want to cause this part less than the whole to be conveyed. And then finally, we talk about public policy. And I think the only time that you cannot enforce the language of these CCNRs is if it would offend public policy, if you look at CSA. And I think that the public policy goes the other way. The HOA is there to talk about these disputes. We'll have 148 adverse possession claims. On the other side, you say, well, why isn't everybody moving their walls? Because they have to get permission from the HOA. The HOA can solve this problem. And I'm out of time.
Thank you, counsel. We certainly appreciate the chance to talk with you this morning. It always helps us. We're going to take the matter under advisement at this time, and we will issue a decision in due course. Thank you.